Yeah, in this video, man, y'all gonna smash the hell out the like button because I'm about to destroy the feds in their own paperwork, bro. This is was so ridiculous. But we gonna read it. Y'all like to pop in, pop out. So that's what we gonna do. I'll read about 2, 3 pages at max 4, but it's an 8-page document. So I'll read about 3 pages, pop in, pop out. Let's go. So as y'all can see already right here, they had to change the title for Bilal Esley, right? First assistant United States attorney. First assistant? I thought she was top dog. I don't care. I don't like the feds. I don't wish no harm to the feds because I know y'all watching. I just don't like y'all. It is what it is. And I know the feeling's mutual, especially after this. United States plaintiff versus Durk'S defendants. Reply in motion of government's motion to impanel an anonymous jury. Plaintiff United States of America hereby files its reply in support of its motion to impanel an anonymous jury, docket number 235, right? And this reply is based on the attached memorandum of points and authorities, the files and records in this case, and such further evidence and argument as the court may permit. Respectfully submitted. Bilal Esley, yeah, November 10th. Don't worry, we finna dig all in through this, buddy. This finna get BADDD. Anyways, juror confidentiality is one of the security measures this court should adopt to ensure a fair trial, prevent improper attempts to influence jurors, and to otherwise protect the judicial process. Defendants do not meaningfully grapple with the facts that support anonymity, e.g., the violent history of defendants and their associates, OTF associates' willingness to use violence against OTFs and defendant banks' rivals, and witness tampering that has already occurred in this case. No, it actually hasn't. And I'm going to tell you guys why in just a moment. Let me get these next sentences out. And defendant banks' contempt for the judicial process, including his obstruction of an investigation into his clandestine, unmonitored jail communications. Instead, defendants brush them aside as speculation and mischaracterization and minimize, the consequences of defendants' own words and conduct. Really? So what they're doing, right? And was so funny, right? There's this word called remedies, right? What are you going to do to fix the problem? So far from the last one, they ain't did nothing. And I want y'all to understand it because what they're doing is they're trying to characterize it to the judge to tug on the heartstrings of, hey, judge, listen, man, we have to keep everything sacred and treat these witnesses like they're going to die immediately. Once they leave the courtroom, it's over. Really? Let me ask you a simple question, and this is going to be the theme that we're going to use to destroy the feds. As far as the law goes, not in a real way. As far as what they're saying, let me say that because last time the feds took my words out of context. How is it that the feds are full of it in my belief? Can I prove it? No, I just have a theory. Feds, people, if there were such witnesses that had such a threat to their life, and you had all this technology that you could pinpoint people getting on planes, transactions, even buying ski masks at Big Five. Wow. You could do all of that. One would think you could find out people who would do these things as well. If this was really about people and justice and Durk'S being who y'all say he is, this would include no less than 10 people. The cats that are sitting in the jail cell right now in Illinois would be transferred and held until now because Durk'S is so violent that he would be able to get them up out of here, right? So no transfer of the 2 killers who killed Stefan Mack. They're not transferred to federal custody. Y'all do know that, right? First problem. Shall we continue? I think we shall. Roll it. The crux of defendant's opposition is what it fails to contest or even mention, that defendant Banks instructs his willing associates to hunt his rivals, that defendant Banks, Wilson, and other OTF associates have already tried to influence cooperating witness testimony, and that OTF affiliates and supporters have already shown their willingness to threaten ththose involved in this high-profile trial. These facts strongly weigh in favor of heightened measures to safeguard the jury's fact-finding mission and secure juror safety. Moreover, defendants do not contest the well-established law that a thorough jury questionnaire and a neutral explanation for confidentiality adequately protect the right to meaningful voir dire. At bottom, withholding a limited set of jury information from both parties, coupled with the Ninth Circuit approved proactive measures, are constitutionally permissible steps to ensure a safe and fair trial. Question to you. How long have you been following this channel? I want to piss off people. Hit that like button real quick if this makes sense. Isn't one of the charges against YNW Melly witness tampering? Isn't that what YNW Borland was told? Who's being charged with witness tampering now? Okay. Did I earn your like with that one right there? Cool. Let's continue on. An anonymous jury will protect the jury's fact-finding mission and ensure juror safety. Defendants attempt to isolate and downplay each of the non-exhaustive factors this court considers when evaluating the need for juror anonymity. Their analysis misses the mark at each turn. First, defendants contend that defendant Banks has no affiliation with organized crime and that OTF is a record label and professional entity. Nothing more. Op 812. The government does not dispute that OTF is, in part, a legitimate business operation, but OTF's and defendant Banks' public success does not contradict or undermine the material facts showing the organized nature of certain OTF associates, criminality, and violence. Indeed, defendants do not contest that two shooters charged with murder in the Northern District of Illinois discussed payment from OTF and defendant Banks following the execution of a Chicago gang member motion at 9 that OTF associates, including the defendants in this case, act at defendant Banks' direction and with his funds to hunt and exact revenge on OTF's rivals, motion at 8, and that defendants and other OTF associates have violent criminal histories, motion at 6. Rather, defendants claim that the facts are too attenuated to demonstrate a risk to juror safety and impartiality. As explained in the government's motion, these facts demonstrate the capacity of defendants, OTF's associates, and/or their supporters to intimidate those who may pose a risk to the liberty of OTF members, including jurors who will render a verdict in this case. Second, defendants proclaim that there is no risk of interference with witnesses in the judicial process, op-ed 12, emphasis added. But defendants fail to mention the actual interference that has occurred in this case. OTF associates, threats to, and intimidation of suspected government witnesses. Really? So these ain't even y'all witnesses. These are people that they saying they think is snitching. See motion at 11 through 12 in under seal filing detailing events. The defendant Banks' contempt for the judicial process is demonstrated by his obstructive conduct at the MDC motion at 13. Instead of analyzing these tangible facts, defendant Banks claims that his explicit disdain for cooperating witnesses, I hate all rats, is immaterial to the court's analysis since unrelated public figures have purportedly made similar comments, op-ed 13. But the totality of facts presented by the government show that defendants and their OTF associates have demonstrated their willingness and capability to interfere with this trial and impair the jury's fact-finding mission. Third, defendants' argument that media attention cannot alone justify anonymous jury, op-ed 15, misconstrues the government's argument. This court analysis considers 5 non-exhaustive factors and its peculiar context-specific inquiry. We're going to stop right here real quick. Let me tell y'all something. Feds, y'all suck at this. Y'all really suck at this one right here. He told y'all why he hates snitches. See, if I tell you, you know what? I hate ice cream. You know the first thing you guys are going to ask? It's a 3-letter word. It's very powerful. Why? Yeah, man, I hate ice cream because it gave my mom a brain freeze and she sat down and she broke my favorite toy. Yeah, she broke the Black Power Ranger, bruh. Sat on it. And it wouldn't have happened had she not ate ice cream. So in my childhood, I hated ice cream. I hated it. I hated ice cream. So if you ice cream, I hate you. I hate all ice cream. Durk doesn't like snitches because snitches, the snitch, rats, they took his hero away from him. His father went to the feds because he was snitched on. You don't think that a little boy would dislike individuals that he believes is the reason for his father not being here? Feds, you guys suck. Let's go. United States versus Dinkin, 691, F3D, 3, whatever the hell. Both parties agree that this case has and will continue to garner significant media attention. Motion at 8. And it is undisputed that the publicity has already led to attempts to intimidate individuals connected to this case. Motion at 8. It is therefore not speculative that defendants and their affiliates and/or their supporters pose a risk to the integrity of the jury's fact-finding mission. Finally, defendants contend that although the protection of juror information from the public and media may be appropriate, an anonymous jury impairs the defense's ability to conduct meaningful voir dire, undermining the right to an impartial jury under the Sixth Amendment, op-ed 17. But potential jurors do not lose their expectation of privacy when they are summoned into court. See Branberg versus Lucas, 891 F sub 352-357. ED text 1995. A determination of the relevancy of the inquiry into jurors' backgrounds and a balancing of the competing rights to privacy must be performed by the court. While the parties have attorneys to champion their rights, the courts must protect the privacy rights of the prospective jurors. Idea 356. Defendants do not offer a single concrete example of how they would be prejudiced by defendants and their counsel not knowing the name and home address of a juror or or the name or address of the juror's employer. Not one of these facts goes to bias or impartiality. The parties will be provided with the juror's city, occupation, in addition to other non-identifying facts concerning the jurors, such as prior contacts with or relationships with law enforcement. There is no need for personal identifying information, particularly considering the use of a thorough jury questionnaire, see United States versus Barnes, if giving the names and addresses had been required so that the investigation could have been made in the neighborhood or from their families as to their characteristics, any semblance of an impartial jury would have been destroyed. Fear of retaliation against them or members of their families would inevitably have been uppermost in their minds during the deliberations. Finally, defendants' counsel concede that while keeping the jurors' personal identities anonymous, to the public may be appropriate, counsel should still be given access to the personal identifiers. That presents an unacceptable risk of unintended disclosure, given the lack of probative value in jurors' personal information. The risk of unintended disclosure is certainly possible in court findings. Branberg, we ain't finna do all that. Basically, defendants offer no explanation of how sitting at counsel table with their clients while conducting voir dire, they can assure that their clients will not discover the names of the jurors, given the risk to jurors and their families and the trial process itself. Defendants present no persuasive reason for their counsel to have the names and addresses of their potential jurors. So how often can a judge instruct a defendant to sit by a certain witness, a certain spot, a certain whatever the hell? So I'm just curious, right? I'm just curious. If we had somebody who stayed in a PW, was it predominantly white? Yeah, in a predominantly white neighborhood with an affluent community that makes, I don't know, the per medium is 500,000, a whole bunch of people in law enforcement and all this stuff. You're telling me that they won't have an obscured view of young guys with tattoos on their face and long hair and all that, and their black skin? It's said to be a jury of your peers. So find some rich ass black people. No. What they're doing, right, is they're setting this up to be broadcast to the jurors. Jurors, you guys are in trouble, man. These guys are dangerous. And if he loses this case, you could die, is what they're putting out there to the public. Don't forget that. Imagine if you were a juror and you came in and the circumstances were so crazy that you couldn't just sit down, get ready with your notes, write down what you think is pertinent information, and what you don't think is pertinent information will not be written down. But the security measures make it feel like, goddamn, I'm checking into a base. You don't think that in the back of your mind, you're going to be thinking to yourself, damn, bro, I'm prejudiced him because they're trying to protect me. He definitely did it. Get the fuck out of here. Let's go to the final point. The government respectfully requests that this court impanel an anonymous jury to protect prospective jurors and prevent any interference with the judicial process. Specifically, the government requires that the names, addresses, and specific places of employment not be revealed to either party. Right. Let's destroy this shit. For my people who don't like the swearing, I apologize. Let me try not to swear and use profane language on this. The government is operating in obfuscation, mendacities, lies, if you will. You want to know how I know? Durk ain't seen none of the evidence. So when they say he's on the phone, he's talking through the watch and all that stuff, he's talking to family. They know that. This ain't nothing but scare tactics. Not a shred of proof. None. I'm over here, I'm like, let me read this. Okay. I read that line. Okay. Where's the proof? You see, it's the feds, bro. It's the feds. I'm speaking from personal history. I got snatched by the feds for playing on the internet saying they should do something. If I got snatched by the feds, who the hell y'all think y'all fooling, bruh? This how I know y'all full of shit. Because I'm like, damn, bruh. Y'all use crazy ass words. Y'all said witness intimidation. What witness? Y'all even said, oh, purported witnesses. Who they think is witnesses. Who? Who did it? And then if y'all was that good, bruh, why is it that y'all could put certain things under seal? And under seal works, but under seal with these people don't work with the jurors. So y'all ain't gonna show names, messages, recordings. Let me read the room. Okay. Y'all trying to scare the damn judge into scaring the damn jurors. This is a weak attack. See, let's take what the feds say, right? Because it's clear all they are great manipulators. That's all this is. Once the internet starts to turn and y'all start seeing more people say, damn, bro, probably should have rolled with Ceddy Nash. Even though he OTF, man, we still got to roll with Ceddy Nash because, bro, this is some manipulation shit. Let me make this emphatically clear. If you are threatening a federal witness, a federal informant, a federal anything, the feds will come see you about that. They'll drop names. They'll drop receipts. They'll drop voicemails. They'll drop a whole bevy of things. The reason why they want the Illinois case in with Stephon Mack is so that they can paint Lil Durk and say, look, everybody knows that he has bounties on people. There was these guys that killed this guy that they thought actually killed his brother. They came to see Durk for the money and got paid. Durk paid them for his reputation, not even knowing if these guys actually killed his brother or not. He doesn't even know that he actually may or may not have paid for the hit, but his reputation brought them in. That's why that Stephon Mack shit is in here. Durk is not charged in that at all. All the dude said was he was shaking ass on camera. He went to go kick it with the biggest rapper in Chicago. And that's that. And then when asked about the money, the guy literally said, nah, I ain't get this from Durk. Dude even said, hey, bro. Did Durk give you that money? Fez is full of shit. But if you disagree, how? Let me ask you a question. Imagine if you had a family member and that family member came up to you and said, hey, bro, yeah, these cats they're bad. And they're threatening me and they did all this stuff and everything. And they got people that'll kill you. And you say, who? Guy down the street. Oh, guy down the street. Yeah, I heard he wasn't a good dude. Yeah, me too. I'm telling you, bro, he gonna do something to somebody. How you know? Well, because it was dudes that did something across the street to some other dudes, and then they went and kicked it with him. So because they kicked it with him, he must have knew. He must have knew that he beat them dudes up pretty bad, and then they went and hung out with the dude that we don't like. Yeah, all right, cool, but how you know dude just ain't popular? No, he is. He's the most popular person right now. So did he beat up the dude across the street with them? Did he help them beat the dude up? Nah. But the dudes came back, and they came back with shirts because allegedly, according to everybody, they beat up dude because dude's brother had beat up his brother, so they came back with shirts. But how do you know that he gave him the shirts for that? Well, you just gotta know, bro. That's what the feds are doing. Subscribe, turn on bell, stay notified, share to keep your people aware. Hit this like button to piss the feds off. But if you are the feds, don't hit the like button. Don't hit the like button. Only hit the like button if you're not the feds. But also comment your thoughts on this. Did I get it wrong? Did I get it right? Am I too far into the OTF team? Is me and Drew feeling cooking up something? Or do y'all believe like me? Feds are trying to intimidate the damn jurors. Because with this intimidation to get your ass locked up, we don't know nothing. We don't know shit. Anybody can speculate. Hell, they said I was one of them people supplying Durk with guns. They said I was a cooperator number 6 or number 5 or some shit like that. Anybody can be anything on the internet. You can also be a winner of this PlayStation, this Xbox, by commenting your thoughts right now and hitting that subscribe button, having that bell on. Other than that, man, I'll catch y'all in the next one. Click right here to see how B.O.B. put his T-O-N-G-U-E on some poo-nee-nee. Click right here, or click right here for the playlist. I'll catch y'all in the next one.